Well, good afternoon, everyone. I'm Susan Karmanian, Dean of the College of Law at Hamad bin Khalifa University here in Doha. I'm delighted to welcome you to this webinar titled The QFC Regulatory Tribunal and the Resolution of Regulatory Disputes in Financial Zones. The Hamad bin Khalifa University College of Law is co-hosting this event with the Qatar International Court and Dispute Resolution Center. This is our third webinar since August with the Qatar International Court and Dispute Resolution Center. HBKU Law is honored to have an agreement with the Qatar International Court, and through it, both institutions are contributing to understanding and building legal capacity. In particular, I would like to thank the Chief Executive Officer of the Qatar International Court Dispute Resolution Center, Faisal Rashid Al Sahuti, for his continued support of our relationship and his dedication to promoting justice in Qatar. With us here today is the court's registrar, Christopher Grout. We thank him in advance for his continued support, as well as Sir William Blair, also here with us today, who's been a judge of the Qatar International Court since 2017 and is chair of the Qatar Regulatory Tribunal. To introduce them and the rest of our distinguished panelists, I will pass the floor to my colleague, Professor George Dimitropoulos. Professor Dimitropoulos is an expert in the field of administrative law, international trade and investment law, and dispute resolution. And he's the editor of an upcoming book on international commercial courts. I'd like to thank him and my colleague, Sandia Monis, for their hard work in putting this event together. So George, the floor is now yours. Thank you so much.
Many thanks to you, Susan. I'm delighted to be here with you and all our speakers. So this is a matter of a small introduction, both to our topic as well as to our distinguished panel. So financial zones and other forms of special and free economic zones are spreading all over the world. Zones such as the Qatar Financial Center, the Astana International Financial Center, the Dubai International Financial Center, and the Abu Dhabi Global Markets are responsible for a series of institutional innovations, among which, of course, international commercial courts. We tend to think, and rightly so, of international commercial courts as the fora for the resolution of commercial and more broadly private law disputes. The courts address many more issues than these. They adjudicate a variety of disputes ranging from contractual to employment to administrative and regulatory matters involving a public authority and an individual or private company. Financial zones have their own regulators and administrative authorities that are usually separate from the authorities from the jurisdiction of the home. Zones have created specialist judicial institutions with specific regulatory expertise in order to hear and resolve regulatory disputes. Others have simply left that responsibility to the court that has jurisdiction to determine any type of dispute which relates to the financial zone in question. This, among other things, will form part of our today's discussion. We look forward to hearing from our distinguished panel on various issues relating to the resolution of regulatory disputes within the context of specialist financial zones. Our first speaker for today is Sir William Blair. Sir William has been chair of the QFC Regulatory Tribunal since 2019, and he previously held this role from 2009 to 2011. Sir William is also Professor of Financial Law and Ethics at Queen Mary University of London and Associate Member at 3VB Chambers, London. Sir William has, of course, served previously as a High Court judge in England and Wales and was judge in charge of the Commercial Court. Our second speaker is Christopher Grout. Christopher has been the registrar of the QICDRC since 2012 and is the registrar of both the Qatar International Court and the QFC Regulatory Tribunal. In 2019, Christopher was appointed as a Deputy District Judge in England and Wales. Chris Campbell-Holt, our third speaker, is the registrar and the Chief Executive of the Astana International Financial Center Court and International Arbitration Center, as well as an enforcement judge of the AIFC Court. He's also a member of the AIFC Legal Advisory Council, which reviews and approves AIFC law. Our fourth speaker is Saima Hanif, barrister at 3VB Chambers, London. Saima's global practice spans global banking and financial services, commercial litigation, insurance, and commercial judicial review. Saima has been appointed Queen's Counsel with effect from 15 March 2021. So we're happy to take questions at the end of the webinar. You may direct your questions to all panelists to make sure your questions are visible to all of us. Please use the Q&A tab on the right-hand side of the WebEx screen to pose your questions to our speakers. Users of WebEx on mobile should click on the three dots at the bottom of their screen and then click on the Q&A button. Without further ado, allow me to give the floor to our first speaker, Sir William Blair.
Well, thank you for the kind invitation to speak at HBKU College of Law. And thank you, Dean Karamanian and Professor Dimitropoulos for the introduction. I know that for students, the main topic of interest today is administrative law and administrative remedies. So today's webinar focuses on a particular type of administrative remedy, namely that which applies to penalties imposed by a financial regulator. Let me paint in some of the background. Because finance is so important worldwide, financial regulation is equally important. My colleague, Saima Hanif, will speak more about this from a practitioner's viewpoint. Qatar has a respected system of financial regulation through the Qatar Central Bank and the Qatar Financial Markets Authority. The Qatar Financial Center, QFC, was established about 15 years ago to encourage inward investment. It has its own regulatory authority. In this region, there are similar financial centers in Abu Dhabi and Dubai. However, unlike that in Dubai, the Qatar Financial Center is not a financial zone. It takes its place fully within the Qatari system. So, why a regulatory tribunal? Let me answer that by reference to an actual case that was decided last year. The case involved a trust company incorporated in the QFC, dealing in asset management. The regulatory authority decided that it was not complying with anti-money laundering rules. To be clear, it was not alleged that the company was itself laundering money. The allegation was that the company did not have adequate systems and controls. Money laundering and its prevention is rightly treated very seriously in Qatar. The regulatory authority imposed a fine on the trust company of 25 million Qatari riyals and ordered payment of over 800,000 Qatari riyals for the costs and expenses of the investigation. This follows the practice of financial regulators in other countries. They are typically empowered to impose financial penalties of this kind. But someone who is subject to a penalty by way of administrative decision of this kind must have access to an independent appeal. This is important not just as a matter of due process, but also because if there were no checks on the regulator's power, people would be reluctant to invest. This is the task of the Regulatory Tribunal, which is independent of the QFC. A further appeal lies to the Qatar International Court. To go back to my example, in this particular case, the appeal was dismissed both by the Regulatory Tribunal and the further appeal to the court was dismissed as well. The Regulatory Tribunal is fully integrated within the Qatar International Court and Dispute Resolution Center. One way to look at it is as a specialized court in the administrative field. I understand from Professor Dimitropoulos that you are very familiar with the differences in approach between the civil law and the common law as to administrative remedies. This is less important in the field of financial regulation than in some other areas of administrative law. So why is this? It is because the modern system of financial regulatory law, covering everything from complex financial markets to ordinary consumer contracts, such as you and I enter into when we enter a contract of insurance, have tended to converge around international standards. Again, let me give an example. There are nearly 30 countries within the European Union, each with their own system of law, both civil law and common law countries. However, there is a single board of appeal from decisions of the 3 European financial supervisory authorities. I was the first president of the European Board of Appeal, and I can say that the civil law and common law traditions both played their part in our decision-making. We find the same in the Regulatory Tribunal and in the court itself. I am really delighted that our most recent appointment as a judge of the Regulatory Tribunal is Dr. Muna Al-Marzouki. She is a professor at Qatar University. The registrar of the court is also registrar of the tribunal, an arrangement which also works well. Christopher Grout will say more about this in a minute. Let me close with an important aspect of these appeals. You are very familiar with the standard of review at common law, which focuses on process and the rationality of the administrative decision, as opposed to the standard of review in the civil law, which focuses on proportionality and is generally more interventionist. The Regulatory Tribunal, like similar bodies internationally, is not limited to the common law standard. It considers an appeal on the merits. This means that it can reach its own decision on the facts and is not limited to reviewing procedural errors by the authority. That is, of course, an important distinction in administrative law generally. Thank you.
Sir William, thank you so much. It was wonderful, as well as the comparative outlook in your presentation. Let me ask you, do you expect the number of appeals before the QFC Regulatory Tribunal increasing over time?
That depends on the number of administrative penalties that the QFC imposes. By the way, another very important administrative penalty is prohibition. Not a fine, but prohibiting a party from carrying on business. Now, as you can see, that is a measure that effectively brings a business to a close. Having said that, generally, parties do accept penalties imposed by financial regulators. That is because if they want to continue business, they need to continue to have a good relationship with financial regulators. However, as a matter of fact, there has been an uptick in the number of appeals since 2019. I think that's probably just the way it's worked out. I don't think there's any particular reason for it.
Wonderful, thank you so much. And we will return to Sir William during the Q&A session. Thank you so much for now, Sir William. And the floor goes to the registrar of the court, Christopher Grout. Christopher.
Thank you very much, and good afternoon to everybody. I'm going to try and cover 4 areas in my short presentation today. The first is to give a short introduction to the Qatar Financial Centre more generally. The second is to talk about the establishment of the Regulatory Tribunal and its jurisdiction. The third is to look at the legal framework in which the Regulatory Tribunal operates. And then fourthly, time permitting, we'll have a little look at the procedural rules that apply to cases that are filed before the Regulatory Tribunal. Turning then to the first point, which is about the Qatar Financial Centre. In order to understand the work of the Regulatory Tribunal properly, it's important to look at what precisely the Qatar Financial Centre is and what sort of decisions might be made that are subject to appeal before the Regulatory Tribunal. So in short, the Qatar Financial Centre is an onshore business and financial platform. As Sir William Blair noted, unlike its comparator in Dubai, it doesn't have a physical boundary. There are many advantages for companies that wish to establish in the QFC, not least that they can have 100% foreign ownership of their companies. There is unlimited repatriation of profits, 10% on corporate tax. To date, I believe there are approximately 1,000 companies that have registered with the QFC, and those numbers are growing on a monthly basis. Importantly, for present purposes, there are three independent authorities within the QFC Authority, the QFC Regulatory Authority, and the QIC-DRC, which comprises two judicial institutions, a civil and commercial court and a regulatory tribunal. It's also worthy of note that Article 7 of the QFC law establishes the QFC Companies Registration Office, and Article 6 of the QFC Employment Regulations, read alongside Article 6 of the QFC law, establishes the Employment Standards Office. Now, turning then to the jurisdiction of the Regulatory Tribunal, it's important to note that, as I mentioned a moment ago, there are two very distinct judicial bodies within the QIC-DRC. The first is a civil and commercial court, the jurisdiction of which is primarily found in Article 8.3c of the QFC law. And in short, and as its name suggests, it's concerned with resolving civil and commercial disputes that are in some way connected with the QFC. The Regulatory Tribunal's role, however, is very different. It has a statutory role, which is to be found in Article 8.2c of the QFC law, which provides that the Regulatory Tribunal shall have the jurisdiction to hear appeals raised by individuals and corporate bodies against decisions of the QFC Authority, the Regulatory Authority, and other QFC institutions. In relation to what constitutes a QFC institution, we know from the definitions section of the QFC law that a QFC institution means either the QFC Companies Registration Office or any arbitral body or other institutional body created under Article 6 or Article 9 of the QFC law. Well, we already know from what I said a moment ago that that includes the Companies Registration Office and the Employment Standards Office. And so in short, we know that the Regulatory Tribunal has jurisdiction to hear appeals against the following bodies: the QFC Authority, the QFC Regulatory Authority, the Companies Registration Office, the Employment Standards Office, plus any other institutional body that's created under Article 6 and 9 of the QFC law. But what does that actually mean in practice? Well, it's worth understanding, albeit briefly, what each of those institutions do. Now, it may be that people from those institutions are watching this webinar, and if they are, I don't wish to do them any disservice by summarily describing what their respective institutions do. But I don't have time to go into any great detail about what they do, save to say the following. The QFC Authority is essentially responsible for managing and maintaining the legal and tax environment of the QFC. And it also licenses firms to conduct business in or from the QFC. The Regulatory Authority, as its name suggests, serves as the independent regulator of the QFC. And its primary role is to authorize and regulate firms and individuals who are conducting financial services in or from the QFC. The Companies Registration Office is responsible for registering new companies in the QFC, maintaining a public register of companies, receiving company filings, and, where required, dissolving QFC companies. And finally, the Employment Standards Office, its role is set out in regulations. Its primary duty is to investigate any contravention of the QFC employment regulations. And so it's necessary to understand, albeit briefly, the roles of those respective institutions, to then understand what sort of decisions they may be making, which are liable to end up on appeal before the Regulatory Tribunal. Now, Sir William Blair has already given a case example of the quite severe financial penalties that can be imposed by the regulatory authority, along with orders of prohibition. And it's those sorts of orders that are commonly appealed before the Regulatory Tribunal. But as you will gather from the list of institutions that are established within the QFC, those are not the only type of cases that may end up before the Regulatory Tribunal. The Employment Standards Office, for example, is responsible for investigating complaints raised by employees and employers where allegations of breach of the employment regulations are made. Now, a determination that's made by the Employment Standards Officer is equally subject to appeal before the Regulatory Tribunal by an aggrieved party. And similar observations can be made in respect of both the QFC authority and the company's registration office, who may take decisions during the course of their involvement with QFC companies, all of which are liable to appeal before the Regulatory Tribunal if an individual or a corporate body is aggrieved by a decision that they have taken or not taken. Now, I'm mindful of the time, and I don't really have time to go through the procedure. And in any event, it's something I have gone through with the administrative law class before. But what I would like to end on is to say something about the legal framework in the QFC in which the Regulatory Tribunal operates. Now, generally speaking, the Regulatory Tribunal is only concerned with the laws, regulations, and rules of the QFC. And as students of George's class will know, the QFC has its own laws and regulations, which are generally applicable within the QFC environment. Now, importantly, in addition to primary legislation, both the QFC and the QFCRA have rulemaking powers. And if one looks at the jurisprudence of the Regulatory Tribunal, you will see that what is often alleged that ends up in resulting in an appeal before the Regulatory Tribunal are breaches of the various rules that the QFCA and QFCRA have enacted. Of course, in the case of the Employment Standards Office, it is breach of the employment regulations, which gives rise to an appeal before the Regulatory Tribunal. But although that is true, it's worth pointing out that the Regulatory Tribunal does seek to apply international best practices in its decision-making. And again, if you look at the jurisprudence of the Regulatory Tribunal, you will see that in a number of its judgments, respected jurisprudence from foreign countries is often cited both by lawyers in argument and by the tribunal in reaching its decision. And so that is a whirlwind tour of the background to the QFC, the jurisdiction of the Regulatory Tribunal, and the legal framework in which it operates. And I will very happily answer any questions at the end of the session, should anyone have any.
Christopher, thank you. That was to the point overall, great as always. Thank you so much. Allow me to pose one question to you already at this stage. So how does the Regulatory Tribunal ensure that parties to a dispute are on an equal footing, particularly in circumstances, right, where cases will inevitably involve emanations of the state on the one side and individuals and companies on the other side, as are, you know, the cases before the Regulatory Tribunal?
Thank you, George. It's a really important question because, as you rightly identify, the likelihood is that in a case before the Regulatory Tribunal, there will be on the face of it an imbalance of power because you have a state institution on one side and then you have an individual or a small business on the other. And the Regulatory Tribunal needs to ensure that when that happens, the parties are, so far as possible, on an equal footing. And indeed, that is something which is actually explicitly set out in Article 4 of the Tribunal's own regulations and procedural rules. So it's under a duty to ensure, so far as possible, that parties are on an equal footing. Now, that is easier said than done in circumstances where you may have an unrepresented litigant on one side and an institution on the other, which is represented by an in-house legal team and perhaps a very senior lawyer, either sourced locally or from abroad. But some of the steps that the tribunal utilizes in order to ensure fairness between the parties is even though an appeal will inevitably be brought by the individual or the company, it is usually as a result of directions that are issued by the Regulatory Tribunal, incumbent upon the QFC institution to ensure that it files, for example, an agreed hearing bundle in respect of the hearing before the tribunal. So it effectively shifts the burden, the administrative burden of preparing the papers onto the QFC institution rather than requiring the individual to do it. Another really important point to make is that particularly in the case of unrepresented litigants, the QICDRC has enacted in the course of last year a pro bono scheme, which HBKU has kindly offered its support to. And that pro bono scheme, with the help of both Qatari lawyers and international lawyers, helps to ensure that if we do have cases where parties are unrepresented, they are offered in suitable cases free legal advice and assistance in respective cases before the Regulatory Tribunal.
Thank you. Thank you so much, Christopher. And if our audience has further questions on these or related matters, feel free to address them. And I would like to also welcome Chris Campbell-Holt to our HBKU community. Chris has, a great experience on dealing with these and related matters, both in Qatar as well as, of course, now in Astana. The floor is yours, Chris.
Thank you very much. I'd like to start by saying thank you very much indeed to HBKU for inviting me on behalf of the AFC Court to give a brief presentation to you all today. In particular, I'd like to thank Dean Karamanian and Professor Dimitropoulos. Thank you very much indeed for your interest in our project, and particularly to look at perhaps a slight comparative analysis with what's already been provided in Qatar. Qatar is a place which will always have a warm place in my heart and my family's heart. I moved to Qatar from London in 2010, and I was there for close to 7 years, during which time I was extremely fortunate to work with Sir William Blair for a short period and with Lord Wolfe, the first president of the AFC Court. During that time, I was engaged in a limited way with regards to the Regulatory Tribunal, the QFC, during the chairmanship of that tribunal of Michael Thomas QC. Together with other members of the tribunal, we were fortunate to handle a number of appeals. I'd like to offer the most warmest congratulations to the team of the QFC Court and the Regulatory Tribunal for the very considerable success that they have had together over many years now. And it is towards the QFC Court and Regulatory Tribunal that our court in Qatar very much warmly looks towards as a badge of distinction that we hope to climb the heights of in the coming years. In terms of what I'm going to say in the time I've got, I will be brief as requested, but a simple introduction, if I may, to Kazakhstan and the AIFC, which is known as the Astana International Financial Center. Astana, by the way, used to be the name until recently of the capital city of Kazakhstan. The city has now been renamed as Nur-Sultan, after the first president of the independent Kazakhstan, which, by the way, gained its independence from Soviet Republic in 1991, and that's His Excellency the Elbacy Nursultan Nazarbayev. Kazakhstan, as I just alluded to, is a post-Soviet country. As I said, it's had its independence from 1991. Geographically, it's roughly the size of Western Europe. It has a population in excess of 18 million people. It is known internationally for having significant natural resources, in particular in the energy sector, oil and gas. One of the aims of Kazakhstan at this time is to, similar to Qatar in recent years and other parts of the emerging market world, if you like, or frontier market, as we consider ourselves to be in Kazakhstan, is to try to find innovative ways to diversify the country's economy. Firstly, of course, to try to improve the status of the economy and to improve the credentials of the country and recognition of the country economically and politically and socially around the world. And specifically with the overriding objective, we hope, of contributing to an improvement in the overall living standard of Kazakh people. The AFC was created going back as far as 2015 was when the initial work began, with the enactment by the Parliament of Kazakhstan of something called the AFC Constitutional Statute. That provided the basis, the skeleton, if you like, for the creation of the various bodies, on which I'll come on to shortly. The overall mission of the AFC, which, by the way, officially commenced its operations in 2018, is to contribute to sustainable economic development of Kazakhstan and the Central Asia region by fostering innovative financial products and services. As a part of that, I'd like to say the AFC, contrary to some people's views, is not a zone. It is a part of the Kazakhstan system. It has its own independent regime, on which I'll come on to shortly. It has a description of a physical boundary, but in reality, it is a club, not an enclave. There are, similar to what you have at the QFC in Qatar, there are a number of critical bodies to the overall provision of financial services, related regulatory activity, and dispute resolution protection of investor rights and interests. Similar to the QFC regulatory authority, the QFCRA, we have AFSA, the Astana Financial Services Authority, which plays a similar role to the QFCRA, but in Sultan at the AIFC. Unlike, I believe, the QFC, we have our own independent exchange, known as the Astana International Exchange, which is working very closely with the overall AIFC legal infrastructure. Underpinning all of the work, if you like, and the business practices within the AIFC is a legal system which has been created. It's very similar to what you have at the Qatar Financial Centre, indeed the Dubai Financial Centre, and in some parts the ADGM system. But we tweaked that, if you like, through our Legal Advisory Council and other advisors who worked with us closely on that legal project development. Within that is a system of regulations and rules, specifically relating to financial regulation, amongst other matters. This is loosely, well, not loosely, but it's modelled on principles of common law, not just the English common law, but common law generally, and international best practice. Again, very similar to what you have at the Qatar Financial Centre. We don't have a separate regulatory tribunal at the AFC, and I'll come on to why in a moment. What we do have is a separate independent common law principle-based court, known as the AIFC Court. That is chaired by the Chief Justice, Lord Mance, who is the former Deputy President of the United Kingdom Supreme Court. Before Lord Mance took his position as Chief Justice with effect from the 1st of February last year, 2020, he was preceded by our first Chief Justice, Lord Wolfe, who I mentioned earlier, and you all know very well, I'm sure, from his time, his many years working in Qatar on the Qatar Financial Centre project. The court has similar jurisdiction in some ways to what the Qatar Financial Centre court has. Lord Wolfe and I personally created that jurisdiction with support of the government of Kazakhstan and other senior advisors from around the world. We have, of course, primarily jurisdiction for AIFC related matters, whether it's an AFC participant or company or entity registered in the AFC, or operational matters in connection somehow to the AFC. But we also have opt-in jurisdiction, where parties who have absolutely nothing to do with the AFC, Kazakhstan, maybe even the region, can, if they so choose, apply to the court for jurisdiction to apply, in theory, any law and any type of dispute that is of a commercial type, that is not criminal or administrative. I will come on to administrative briefly. The court at court of first instance does have, and I'll mention that in a moment, when I come to the financial regulatory aspect of the work of the AFC court, does have specific provision for the hearing appeals of decisions of AFC bodies. So that is the regulator AFSA. It is also the authority, which is very similar to the QFC authority, and other parts of the AIFC. In addition to the court, we have an international arbitration centre. I won't spend any time on that because I don't think it's relevant to the purpose of this discussion. I just want to highlight that we have it as a part of our so-called one-stop shop for dispute resolution within the AIFC. And that's again available, similar to the AFC court, for absolutely anyone who can agree in writing to use it. I'm going to tell you very briefly as a status update, we are now just entering the 4th year of our operations. We are delighted by the success that we think we've had so far, and that is we've now resolved successfully to completion a total of 349 cases. 349 cases at both the court and arbitration centre. Most of this has been done online using our e-justice digital platform technology and offered free of charge to all parties. We've had 11 court judgments and orders so far. We currently have another judgment under consideration by one of our senior judges at the moment, and we've had 2 case filings at the court already this year. We have completed to final arbitration award 10 arbitration awards, and we've had 328 mediation settlements, which we've worked very closely with parties all around the world, in fact, to administer and to seek to assist them to come to a settlement. Parties have come from the UK, Russia, China, India, Italy, Uzbekistan, Kyrgyzstan, Armenia, Azerbaijan, Turkey, and of course Kazakhstan, throughout Kazakhstan. And the areas of law that have been applicable in AFC, Russian law and Kazakhstani law. All of our decisions so far have been enforced within the entire territory of Kazakhstan, not just the part of the Sultan, but the entire territory of Kazakhstan to 100% satisfaction, using our step-by-step procedure, on which I'll comment later if there is interest in me doing so. Like Qatar, we've worked very hard to develop what we consider to be a level playing field. Kazakh lawyers typically do not have the same standards of regulation from bar boards that you might find, say, New York or London or elsewhere around the world. We've developed a special regime for them so that they're able actually to represent parties fairly in disputes. We've rolled out 3 years now of comprehensive training programs to Kazakhstan lawyers. We've trained more than 2,000 lawyers in Kazakhstan so far during the last 3 years, with support from our partners at Cambridge University, University College London, and CEDA, the mediation accredited group based in London, and other partners. Access to justice, like in Qatar, is very, very important for us at the AIFC. With regards to financial regulatory disputes, that happens under in accordance with our procedures. It's for anyone who's interested, it's the AFC Court Regulations 2017, Regulation 26, subsection 5. And in that, we have an independent appeal of decisions of AIFC bodies. I mentioned earlier AFC bodies, it's the regulator chiefly, the authority, and others. The procedure is what you might expect in some other similar minded international financial centres. The following grounds will be familiar, but I'll quote them very quickly if I may. First, there can be consideration of appeal which relates to a question of law. Secondly, on an allegation of a miscarriage of justice. Thirdly, on an issue of procedural unfairness. And fourthly, on a matter provided in or under AFC law. Decisions are made at the court, or will be made on regulatory matters at the court of first instance by one judge, no more than one judge, and those decisions will be final. Now, we decided to do that because our court and our dispute resolution facility is not just for financial regulatory matters. Of course, that's critically important to financial centre, but it does provide jurisdiction for all types of other investments coming to the AFC in Kazakhstan and the region. The AFSA already has a detailed complaints procedure as a first place to go for potential appellants on decisions that the regulator AFSA perhaps have made. If that's not to the liking of the appellant in the first instance at complaint level, then they can seek the support of an independent committee of experts on financial regulatory matters. Failing all of that, the appellant would then have a right potentially to apply to the Court of First Instance at the AFC Court for a final appeal decision. We have not been tested, despite our 349 cases so far. We have not yet received a financial regulatory appeal case at the AFC Court. I suspect it's still too early for that, given that we're still only just entering the 4th year of our operations as an AFC Court at the Financial Centre. However, I do know that there have been some discrepancies perhaps in the behaviour and conduct of some AFC participants, and the regulator has so far, satisfactorily I understand, been dealing with those internally using their procedures that I've just outlined. Do I anticipate work coming to the court for financial regulatory disputes, maybe from AFSA in the future? Yes, of course I do. Sir William Blair mentioned about the provision of anti-money laundering at the QFC. Well, we also have that. It's been developed from a much earlier stage, of course. We're newer than the Qatar Financial Centre and the AIFC. I understand we have a robust system in place. That's bound to be tested. A lot of the international common law principles and procedures which are now applicable to protect the rights of investors at the AIFC are new concepts in every way to a number of the investors, particularly from within Kazakhstan and the Central Asia region. So I do anticipate mistakes to have been made. I do anticipate potential appeal cases coming to our court. I think that's all I wanted to say in the time I have available. Thank you very much, and I'm open for any questions.
Thank you so much, Chris, for this tour d'horizon around, the Astana International Financial Center as well as Kazakhstan. That was wonderful. Very briefly, let me ask you: can you give us some hints on the enforcement procedure of the AIFC Court and the IAC judgments and awards, briefly, if possible?
This is a topic I could talk to you for hours, but you'd be delighted to know.
So, yes.
So within 30 to 60 seconds, if that's helpful, we have the local law on the local national enforcement law of Kazakhstan has been amended recently to provide for recognition of the AIFC court judgments with it for enforcement throughout the entire territory of Kazakhstan. We do not rely as an AIFC court on the local courts for enforcement. We have no connection other than mutual cooperation and friendship whatsoever to the local courts on enforcement of our AIFC court judgments and orders. We have a step-by-step procedure, which Lord Wolf, when he was our first Chief Justice, signed, firstly with the Ministry of Justice of Kazakhstan, directly with the Minister himself, and secondly with the National Chamber of Law Enforcement Agents, otherwise known as the bailiffs, which is responsible for assistance of enforcement of court judgments and orders relating to any private assets related anywhere within the territory of Kazakhstan. As the enforcement judge, what happens is we have already gone through this exercise a number of times. It's always been successful without fail, and the reason for that is because we have this procedure. I don't want to comment on the local courts, our friends, but we have been robust, we've been immediate. A very quick example of practice, we had an arbitration award from our arbitration centre. It needed to be, in fact, we've done this 3 times so far. Last year, that arbitration final award needed to be enforced throughout the territory of Kazakhstan, in various parts of Kazakhstan. It came to us on an appeal for recognition and enforcement to the AIFC court. I had one of our most senior judges deal with that application within 90 minutes of us receiving the electronic application. Within 90 minutes from his garden in London, he had drafted his judgment and order. He gave it to me with firm instructions. With the support of my excellent international standard but Kazakh national case management team, we put it together in my execution order in Russian and Kazakh languages to give effect to that judgment and order. It went straight electronically and in person to the enforcement agents directly with the full support of the chairman of the bailiffs. And that case was enforced, which means bank accounts were frozen, assets were seized as necessary within a matter of 1 to 3 days. So we're handling things very, very swiftly with our procedures.
Wonderful. Thank you so much, Chris. And allow me now to pass the floor to Saima. Saima, thank you so much for joining HPKU for this event. We look forward to hearing your views.
Thank you very much, Professor Dimitropoulos, and thank you very much for inviting me to talk today. What I want to touch on very briefly is the practitioner's perspective as to why it's important to have either a regulatory tribunal or an independent court of the sort that you have in the AIFC. So if we just step back for one moment, in every form of regulatory framework in the financial services industry, what you have is a form of control. So essentially, you're interfering with the free flow of the marketplace. Now, embedded within that system of control are standards of conduct which the regulator says are to be expected of participants in the marketplace. Now, within this broad framework, there's a slight tension in how those standards apply. On the one hand, if you want to encourage investment within the jurisdiction, quite rightly, investors have to feel it's a safe place to do so. And quite rightly, they will look to the regulatory framework for that reassurance. However, if the regulation is too severe, there's then a concern that it might impede innovation and it might stifle the legitimate business objectives of firms and institutions. And what I see as a practitioner is that this tension often plays out in disputes between the regulatory body in the form of the investigator or the enforcement body and the party that's being regulated. Now, a classic example of this might relate to the systems and controls of an organization. Now, regulatory standards are by their nature open textured. So, for example, the regulatory standard may be that every firm has an obligation to have adequate systems and controls to prevent financial crime. Now, immediately as lawyers, the first thing that will occur to us, well, what does that mean, adequate? It will have a variety of meanings depending on the nature of the business, the nature of the particular financial crime that this business has to prevent, the nature of its client database, etc. So what you frequently find is that the party under investigation will say to the regulator, well, look, I think I've met this standard because my systems and controls, while there may be room for improvement, they're actually perfectly adequate. What you, the regulator, are doing is holding me to a much higher standard, and you're effectively advancing a counsel of perfection, and that's not correct. So that's one point of tension. When you turn to regulated individuals, they have their own individual standards of professional behaviour. And so a classic one is that all individuals have to behave with integrity. Now, again, that's a very open textured principle. What does it mean to behave without integrity? Because what you're effectively doing is coming to a moral judgment on the conduct of that individual. And you can see how a concept like that will give rise to dispute between the individual and the enforcement arm. And it's in these scenarios that the option of going to an independent tribunal becomes paramount, because what the individual or the institution will have the comfort of knowing is that they can take their dispute to an independent body, which will be chaired by a legally qualified chairperson, and where there will be a full merits review of all the relevant facts. And typically that can often involve expert evidence. And I think particularly where there are difficult questions of appropriate standards to be applied, I think it's paramount that there is an objective body that will look at the facts and then seek to apply those facts to an objectively determined standard of conduct. So that's one key factor as to why it's important to have the tribunal. The second factor that's related to that relates actually to the way that financial markets work. They are now global. Financial institutions are global. You can be living in England and send a huge amount of money by electronic means halfway around the world in the blink of an eyelid. We have incredibly sophisticated payment processes. And then in addition to that, leaving aside recent events relating to COVID, the global workplace has become increasingly mobile. So people work globally in a way that they didn't 30 years ago. What you see as a result of all that is there is increasing cooperation between global regulators. So what you might find is that an individual who may have had a dispute with a regulator in one jurisdiction, who then seeks to move to another jurisdiction, will necessarily find that whatever finding was made against him or her actually is now being looked at by the new regulatory body from whom they're seeking a license to practice. And I think in this scenario, the existence of a regulatory tribunal does become important, because either the individual can say, well, look, I've actually got a case that's going to an independent tribunal, so you, my new regulator, should await the outcome of that before you decide anything. Or secondly, what can be said is whatever the outcome, at least the finding has been reached by an independent party that has looked closely at the facts in question. So I think there is now global importance for tribunals. And I think the third point I want to make, which I think relates to the efficacy and the process before a tribunal. I think one thing that's critical from a practitioner's perspective is that there is a speedy process. And in that sense, it was interesting to hear the process that Chris had described. Typically, whether it's a firm or an individual, if they are taking their case to a tribunal, there is normally a sanction, which, albeit it may not be enforced, it's hanging around in the shadows. So for an individual, if, for example, the enforcement team wants to prohibit that individual, unless and until a tribunal reaches a prompt conclusion as to whether or not such a prohibition is warranted, it will be very difficult for them to find work elsewhere. But that's all to say that in addition to the tribunal itself, the process that it adopts and the speed with which it makes its decisions is also very important for the proper functioning, not only of the marketplace, but also to practitioners who operate within that sector. So that's just a brief overview from a practitioner's perspective.
That's wonderful. Thank you so much, Simon. And if I may follow up, could you please let us know what you think are the current global trends when it comes to regulatory disputes and regulatory disputes?
Absolutely. So there's actually two key issues. So firstly, obviously, we've had the COVID pandemic. What's happened practically as a result of that are two things. Firstly, payment by virtue of electronic means has exploded. So cash, albeit it was in decline anyway, that has effectively overnight practically ceased in some jurisdictions. Now, in the current climate where there are sophisticated payment processes, what you're finding is that is effectively there's now increased scope for fraud in respect of the movement of funds from jurisdiction A to jurisdiction B. So what you're now seeing, particularly for payment processors, is lots of regulatory scrutiny around their systems and controls, and particularly with regard to how you prevent fraud in that sector. The second global trend, which I think actually reflects a political trend, but nonetheless it's very interesting, I think, for regulators and participants in financial markets, is actually global sanctions, whether they're US sanctions or EU sanctions. We now have a very complicated web of economic sanctions, which actually participants in the FS marketplaces can find themselves unwittingly caught up within actually what is a very complicated legal regime. And what we're increasingly seeing actually is regulators across the globe, quite rightly, whether via their supervisory arm or their enforcement arm, are taking greater action as regards whether or not entities have breached those sanctions, and if they have, what sort of steps they've taken to remediate those positions. And I think both of those trends are things which will continue, certainly in the short term.
That's very illuminating. Thank you so much, Saima. And at this stage, I hand over the floor to the Dean.
Great. Thank you so much, George, and to all of our panelists for this engaging discussion. And the discussion continues now online. So please, I ask the audience to submit through the Q&A function their questions. If I could take the liberty of launching the conversation, I trust this is a question that Sir William, Christopher, Simon, and also Chris, you may also have some thoughts on it. But in looking, and I just pulled up the AML CFT regulatory framework for the Qatar Financial Center, and it specifically states that it is underpinned by the law of Qatar, and that it makes reference to the specific law of Qatar. And so this would be for Sir William, but also for all the other panelists, is to what extent is the fact that you are applying QFC standards that are largely shaped by local law, does that affect your analysis and thinking about the broader implications of your decision? Because my understanding is the QFC has a very detailed guidance on the implementation of the law. You can go online and look at all the information about AML. And please unmute.
Thanks very much indeed, Susan. It's a good question. I go back to what I said in my remarks, that if you look at the financial regulatory law that applies in countries around the world, you actually see a lot of similarities. And why is that? As I said, the reason is that international standards set by a variety of bodies have tended to produce a degree of convergence. So in other words, if you look, say, at anti-money laundering law, to take that example, countries around the world have very similar laws. I had to go recently to another country in Central Asia, Mongolia, which I did with the Asian Development Bank, which has a project there. And really, the anti-money laundering laws there, on paper anyway, are the same as those in France, or in Brazil, or in Qatar, or England. Of course, how they're actually applied is different. the systems of financial regulation differ slightly and sometimes differ a lot from country to country, but the actual underlying law is very much the same. So I don't think that the problem that you've adverted to is actually a real one. I think that the standards applied by the say the Qatar Central Bank are very, very high, and the standards applied by the QFC are equally very, very high, and that's important. But I hope perhaps more generally that particularly students listening to what's been a very interesting discussion will, I hope, take from it is just the importance and interest of this subject of financial regulation. It does cover a huge range of things, and it's not really taught in universities particularly. At least at undergraduate level, it may be taught at graduate level in some places, but it's, I think, one of the most important and interesting areas that there are.
Thank you so much. Does anybody else want to chime in on the question? Any thoughts? Yeah, please, Chris.
Please, if I may briefly, on behalf of the AIFC, when it comes to anti-money laundering, as an example, the AIFC does have its own framework, its own system of rules. The idea, if we take that as an example, is to provide so-called new international standards with direct application in a trusted system of regulatory regulation backed with a credible international standard dispute resolution facility applying the stricter standards of the rule of law. So the idea is that bringing new international standards is not a question of questioning perhaps the standards of the existing infrastructure, if there even is an existing infrastructure in some instances with the new innovations being brought at the international standard to the AFC. But the overall feeling is that, and hope, is that what is being set as an international standard at the AFC will rub off on the rest of the country and will have some wider significant positive impact for the overall investment attractiveness of the whole country, not just through the AFC as a vehicle for that investment. I'll give you an example. I'm now sitting as a member of the Supreme Court of Kazakhstan International Council of Advisors and also on the President's Office working group on judicial and legal reform. And that's one example of how our experience at the AFC is being used already, even at this very early stage of our operations as a court and AFC, to have a positive, hopefully a positive impact on further reform in similar areas of regulation and other areas of the law throughout the whole of the territory of Kazakhstan. And it goes beyond that. Kazakhstan is positioning itself, or trying to position itself right now politically, as the center for investments in, and legal reforms for the whole of the Central Asia region. Before COVID-19, we were having to speak in person or whatever at various events throughout the region to market what we're doing, of course, but also with the hopes of trying to positively influence other parts of the region in the same way that I'm talking about are trying to contribute to the overall system of Kazakhstan through the AFC.
Great, thank you. We have a question from one of our students, and it is probably aimed at Chris since it references Kazakhstan. And to what degree is there a balance between protectionist measures and direct foreign investment? And how does the AIFC pivot itself within this sphere?
I don't think I'm the top expert at the AFC to provide a direct answer to this. I'll provide my personal view, if I may. But it is evident through all the work we're doing at the AFC that the focus is very much on attracting not just indirect international investment, but in local investment. One initiative at the moment of which I'm aware is a repatriation initiative to try and bring Kazakh money from outside of Kazakhstan back into Kazakhstan directly through the AFC to fund AFC projects. And that's, in that way, we're no different from some other centres, in particular, I think at Abu Dhabi and others. But everyone is treated the same. But there is pressure from the government to increasingly use our facility, certainly in terms of disputes, but elsewhere, applying the common law, as we've defined it, within the AFC on other projects.
Great, thank you. Let me see if we have any other questions from our students here. It looks like that was the one. Could I just, I know we're getting tight on time, but I'd like to get back to sort of an observation I think that Simon made, and it could open the door for something that Sir William talked about at the beginning too, and that is the standard of review of the courts. And is there a sense of, I know in the United States in administrative law we have a deference standard and the like. Is there a sense of like an emerging within these courts a single standard of review for administrative decisions? Like what if the act was based on an incorrect understanding of the facts or a misinterpretation of the law? How serious would this misinterpretation or misunderstanding be, and the like? And I guess I would ask that for Saima if she has a sense of that, and to anybody else who would like to chime in.
I mean, I think you raised a very good point, Susan, about actually, is there, as it were, a uniform standard that applies, or there's slight nuances? I mean, obviously the standard will differ depending on the facts of each case. But I think when you have enforcement action, I think typically the sorts of standards or the sorts of judgments that are implicit in the alleged contraventions, I do think there is some sense of uniformity. So, for example, if it's said, well, your systems and controls were not adequate, obviously you can have a slightly arid debate about what does adequate mean. But generally, within the factual context, I think there would be some degree of uniformity as to, well, what are the adequate systems for a custodian versus a wholesale bank? And I think this goes back to one of the points that Sir William made at the outset of his talk, where he said, actually, you do see at a global level convergence around the sorts of standards that are expected of market participants. And so I think before the tribunal, when the tribunal is asking itself, well, has that standard been breached? There is, as it were, a common understanding as to what that standard looks like, as it were, in the abstract.
Thank you. If I could just follow up on that, then I gather, getting back to the case that Sir William identified, there was no system of controls in place. Am I correct on that? And so what if there had been, ones that an expert could say, well, these are getting close to what we would expect. So
Susan, the first point I think I'd make is that all the judgments of the court and the regulatory tribunal are online on the website of the QIC, DRC in Arabic and in English. So it's for people who are interested, it's quite possible to go and look. I think in answered your question, this is a matter in the first instance of regulatory judgment, so that the financial regulator, who after all sees all parties who are in any particular financial center, whether it's the QFC or whether it's in Singapore or in the Netherlands or Britain or wherever it may be, the regulator gets to see everything. So it's not just a matter of the standards in the abstract. It's a matter of experienced financial supervisors who draw on their experience to say, these are the standards on paper, but we're also satisfied that that this particular institution has fallen short. But just perhaps to go back to a point that Simon made, it is a matter of judgment, Susan, and judgments can be wrong, or at the very least, a party should be able to say, well, you're taking away, for example, by a prohibition order, my ability to carry on business. I know you think that's the right decision, but it's got such wide consequences for me or my company or my business, large or small, that I want to have that reviewed. And the key point, the really key point, is that the review should be independent, but also that it should have attached to it expertise. Now, in the case of the Regulatory Tribunal, one of our judges is former General Counsel at the International Monetary Fund, for example, as you know well. You know Sean Hagan yourself. Another is former Solicitor General of India, who brings a lot of experience, and another chairs the mediation center in Singapore, and another from the Securities and Futures Commission in Hong Kong. And I myself have a lot of experience in this field. And as I said, our latest judge now comes in, and she will bring, I've got no doubt, a huge amount of insight and experience. But it's these two key points. Why do you have this form of administrative redress? The answer is because you need it.
Mm-hmm.
It needs to be speedy. It needs to be informed, so that the people who are actually making the decision have a degree of expertise themselves, and it needs to be independent.
Great. Thank you. On that note, particularly reminding us, Sir William, of the importance of judgment and what it means to be a judge. I always tell the students that I teach, that's the most important thing you bring as a lawyer, is your judgment. And having it informed and having it independent, having it well thought out with expertise is I think you laid it out perfectly. So on behalf of the Hamad bin Khalifa University College of Law, first I'd like to thank the Qatar International Court and Dispute Resolution Center, and I would like to thank so much Sir William Blair and Christopher Grout and Chris Campbell-Holt and Saima Hanif and my colleague Professor George Dimitropoulos for this wonderful session. I think we all walk away from it more informed about the regulatory work in the centers and the role of courts in this process. I wish everyone to have a good evening, and again, thank you so much. Bye-bye.
Thank you.